The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation building series, The Law and You. This is program number 960, coming to you on Monday the 13th of January 2020. On this program, I will speak to you on the topic life interests. And before beginning the topic, let me say deepest condolences to all families which have suffered recent bereavements. Life interests. From time to time, I have advised that where parents are giving properties consisting of their dwelling houses, their homes, to children, and the parents do not have another house in which to live, those parents should insist that the deed of gift, when drawn up, should reserve a life interest for the parents, popularly known as your lifetime. That advice has been given to you because of several incidents that I know about in which parents have made deeds of gift of the family home to their children, and before long the children have packed the parents off to the Louis Pinette home while they enjoy the property that belonged to their parents, that they got as a deed of gift. Sometimes they place the parents in the Louis Pinette home and hardly visit the parents. They abandon them, as it were. Hence, on previous programs, I have advised parents that when you are contemplating giving your home property to your children or to any other family member, and you have no other place to go and live, but you expect to live there till you die, you say to them, you want the document to show that you have your lifetime in the property. That way, they can't take you out and send you off to live somewhere else while they enjoy the fruits of your labor. So on this program, I will explain some of the key aspects of what is called a life interest in property. The term life tenant is the term used in the law to describe a person who enjoys a life interest in property. The word tenant there has nothing to do with the payment of rent. It simply springs from the ancient usage in England, where the concept of a tenancy had come about in the early days on the theory that all land in England belonged to the crown, but that persons could enjoy a tenancy of the land of such a nature as was prescribed by law and custom. So that if you read any old law books or you read an article on ancient law and you come across the word tenant, it does not necessarily connote somebody renting a place and paying a rent for it. Thus, English land law is based on the concept of tenure. And tenure, T-E-N-U-R-E, comes from the Latin word teneo, meaning to hold. So the theory underlying English land law, and we have inherited English land law, is that all land is held on tenure under the crown. The crown is the superior landholder, and everybody else holds their piece of land by virtue of a special tenancy from the crown. So a person who has a life interest in property is regarded as a life tenant. A life tenancy can arise in several ways. It can arise by an outright gift. That is, somebody has a property, they want to give it to somebody else on condition that they, the giver, must have a life interest in the land, or a person might have a property and might get married after acquiring that property and may want to put the name of the spouse to that property. Now, the person may not want to make an outright gift to the person, to the spouse. Otherwise, if the spouse dies, the beneficiaries would simply include the giving spouse, but the other persons who inherited part of the estate of the deceased spouse. So, a man has property, marries a woman, he doesn't want to give her a half share outright, but he wants to give her a half share to enjoy until she dies. So he gives her a life interest in the property. That's another way in which a life interest can be created. Or a life interest can come about as a result of matrimonial settlement following divorce. So a life interest can arise in different ways. But however the life interest arises, there are certain common elements attached to all life interests. One is that the life tenant cannot alienate the property. In other words, if you only have your lifetime in a property, you cannot sell the property. If you attempt to sell the property and you receive money for that attempted sale, that sale is only valid until you die if all you have is a life interest, because there's a fundamental principle of law that you cannot give away more than that which you have. If something is not yours, then it is not yours to give away. So that where a person has a life interest in property, that person can enjoy the property and the rents and profits from the property until that person dies. But when the life tenant, and remember I said a while ago, life tenant means a person who holds a life interest. When the life tenant dies, the life interest dies as well at the same time. So that if you only have your lifetime in a property, at the end of your life, then that lifetime interest comes to an end. You can't go and make a will if all you have is your lifetime in a property. You can't make a will saying that when you die you're leaving it to so and so. No, because it is not yours to leave in a will. It is not yours to give away. No, you can rent it out. You can hire it. If you have a life interest in property, you can rent out the property and live on the rent. But when you die, those rents belong to the person who gets the property upon your death. And there's another term to which I will introduce you. Well, not in the sense of you hearing it for the first time. You've heard it before, but perhaps not in this context and not in this clarity. That term is remainder man. R-E-M-A-I-N-D-E-R-M-A-N. The definition is in law, especially in land law, a remainder man, and unfortunately there's no feminine of that, so you never have a case of a remainder woman. A remainder man is simply a person, male or female, to whom property comes upon the ending of a life interest that somebody else has in the property. Therefore, back to the example of parents and children. Parents have property, decide to give the property to their children as a deed of gift, reserving their life interest. So that when the parent dies, that property reverts to the children who got it in the first place. Those children become in law, they remainder men. And if only one, the remainder man. And therefore, if you are a remainder man, and this has nothing to do with Brexit, if you are a remainder man, you can look forward to getting the benefits of a property when the life tenant dies. And it has to be death, because life tenancy means tenancy until the person dies, not until the person goes away. And if a life tenant goes away physically from the island, from the country of St. Vincent and Grenadines, and you don't hear from them for a long time, you still cannot treat them as having lost their life interest until such time as the law pronounces that they are dead. And there is a rule, where the 7-year presumption rule, where if somebody goes abroad, and has not been heard about for 7 or more years, then you can go to the court and apply for a presumption of death. That is, you tender evidence before the court to show that this person went away. You have no idea where they are. Nothing has been heard from the person for more than 7 years. Diligent inquiries have been made in the last country where it is known that the person used to reside, and those inquiries have not yielded any information, so that there is nothing to indicate that the person is still alive. So if the court is satisfied with the evidence which is given to the court, then in some circumstances the court will give a presumption of death, namely a certificate to show that this person is presumed to have died after a 7-year absence, unexplained, and the person was unaccounted for, and so on and so on. But let me say, in the same breath, you cannot apply for a presumption of death after 7 years absence fraudulently. In other words, if you know full well that the person went to New York and you have information that they had been seen in Georgia or Texas or Carolina 2 years ago, you can't go to court and swear an affidavit that you know nothing about the person's whereabouts, because your suspicion or your knowledge must be brought to the attention of the court. What you know, whether it is right or wrong, whether based on rumor or what, you have to disclose that to the court and say, my lord, a couple of years ago, I did hear that the person was in South Carolina or Dakota or whatever. You have to tell that to the judge. And the judge will decide on the totality of the evidence whether to make a ruling that the person in all probability is dead. And if you get a certificate from the court presuming somebody has died, you can then say, okay, the life interest has come to an end because the person is no longer alive. Okay? So you cannot lightly apply for a certificate of presumption of death just because nobody has heard anything from somebody for a long period of time. Of course, if the person dies locally, you have a death certificate to prove that the person has died. I'm speaking about where somebody has just left, disappeared, and nothing has been heard from the person. So once a person who has a life interest is alive, that person is entitled to enjoy the property and all what the law calls the rents and profits from the property. Therefore, if a person has a life interest in a dwelling house, there's nothing to stop the person subdividing the house into apartments and renting out 1 or 2 apartments in the same house and using the rent for his or her benefit, because those rents will form part and parcel of the enjoyment of a life interest in the house. Indeed, many dwelling houses now are built with apartments mainly on the lower floors. A lot of people now who build houses build them for the main floor is the dwelling area, and there's a downstairs apartment or 2. Those apartments are meant either for children as they grow big to move into, have some independence, or indeed to rent out, to supplement the income of the person who is entitled to the income from rents for the property. That person would be the life tenant. Because, as I said before, if that person has a life interest in the property, it means the person is entitled to all the income that the property produces. If the property is a farm, the person who has a life interest is entitled to the proceeds of the sale of all the farm products produced on that farm. I heard an argument not too long ago between two persons, one of whom is learned in the law. And the argument went like this. One was saying that if somebody has a life interest in property and they rented out part of it, they're not entitled to the rent. The rent belongs to the remainder man. And the other person was arguing the opposite. Well, the other person was quite correct. Because if, for example, there is a building which is an apartment building, let us say it has 4 apartments, 2 upstairs, 2 downstairs, and the person has a life interest in the whole building, the person can't live physically in the 4 apartments at the same time. Person might live in 1 apartment, might let a friend or another relative stay rent-free in another apartment, and might rent out the other 2 apartments. The life tenant is entitled to collect the rents. No. The life tenant has some responsibilities too. The life tenant cannot just collect income from the property. The life tenant has to pay the outgoings on the property. So when it comes to land taxes, the life tenant has to pay those. Insurance premiums on the property, the life tenant is responsible for those because he has a life interest in the property. He can't ask the remainder man who gets nothing from the property while he waits for the life tenant to die to pay the outgoings on the property. So if you have a life interest in property, you can be expected to have to bear the burden, unless in the document which created the life interest, you have a special clause exempting you from those burdens. But if no clause is put in to say that somebody else will have to carry the expenses of the taxes and insurance premiums and so on, then you know what? Because the law says, he who obtains the benefit should also bear the burden. That's a general rule of thumb, subject, of course, to exceptions, because in law, there are exceptions to every rule. There's hardly anything in law as an absolute rule. Always exceptions, or colloquially, the fine print. So that legal advice should be sought and obtained when one is thinking about creating a life interest in property. Now, I have been using the word property in the context of the law dealing with life interests, that law applies to real property, not to personal property. And you know the big distinction between real property, real estate, is that real property consists of lands and things permanently affixed to the land, whereas personal property consists of everything else. So, vehicles, furniture, jewelry, those would be personal property. And one does not normally talk about life interest in vehicles and other personal property. The term life interest is really confined to real estate, to land, or to buildings on land, or things forming permanently a part of the land. So, to wrap up, if you are thinking of making a gift of your home to your children or any of your children, and you intend to live in that home until you die, you better make sure the document creating that gift, in other words, the deed of gift you sign, make sure it has your lifetime interest protected. Once you have given property subject to your life interest, nobody can throw you out of that or force you to accommodate yourself in a tiny part of the property until you die. You still enjoy the benefits of the property, and when the good Lord closes your eyes, then what happened. You're not concerned with what happens after you have died. Okay? All right, well, that is all from this program of the Law and You, program number 960. I look forward to being of further service to you next week, Monday TV, for another presentation in this public service nation-building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC, and brought to you on SVG-TV as a public service.